Welcome back, everyone. This is Professor McKenzie. Today we're going to be looking at Chapter 15, which involves discharge of obligations. The learning objectives, I want us to understand what is meant by discharge of contractual obligations and how you can actually achieve that status of having your obligations considered discharged. So that's going to be the focus for our discussion today in Chapter 15. So just to kind of quickly review, we've been talking over the past couple of chapters about different facets of contractual obligations. And remember the ultimate end game, the goal for any agreement, whether it's a verbal agreement or if it's an agreement that's written in form, you want to make sure that you've satisfied all of the required elements so that it can be considered an enforceable contract. Without that enforceability, there really is nothing that you can do if the other side decides to not perform as promised. So again, just to kind of quickly recap, remember that we have to have identified, these are all elements that you would have to establish in a court of law if it ends up going to court to be litigated. You would have to establish that there was an offer that was made, that offer had an acceptance, that there was mutual consideration, not just one-sided consideration, but mutual, meaning there was something that was being given up or exchanged that had value for both sides of the agreement. The contract has to involve a lawful subject matter, and that everyone involved has a legal capacity. So if you can kind of check off each one of those boxes, then as we've discussed in the past in this course, we know we have an enforceable contract. And again, that's the ultimate goal. If any one of these elements are missing, then most likely the case will just get dismissed if it's brought into a court of law for failure to establish that an enforceable agreement was originally created, and you don't want that to happen. So when we talk about discharge of contractual obligations, the net result, however you get to that endpoint, and we'll talk about the different avenues or ways in which you can get to this endpoint, but at that endpoint where we can say that your obligation has been discharged, what that means is that it's over. The agreement is over at that point. Sometimes you get to that point or that destination as planned. Sometimes you get to that point or that destination through some kind of mechanism that was not planned. And for the ways that are not planned, it can either be a good or bad result depending on your perspective of how things have unfolded. But the ways in which contracts can be considered discharged, you can actually have performance. So people do what they say they're going to do. If I purchase a car and I finance it for 36 months, I make 36 payments on time. At the end of at that term where I make the last payment, at that point the contract has been completed, and I own the vehicle outright. There's no longer any type of lien on that particular piece of property. So that's an example of just actual performance. We'll talk about discharge by a certain set of conditions. So there's certain things that can trigger a contract to either spring into life or to spring its termination. And so we'll discuss a few examples of those in this chapter. We'll talk about discharge by agreement of the parties. Just as a general contractual principle, you can agree to modify or change virtually any aspect of a contract as long as each party they're able to communicate with each other and they both are in agreement about the changes that are to be made. So, even though you have an otherwise enforceable agreement, you could modify it, you could amend it. You could, just say, I don't want to do this anymore. And if the other side agrees, you both could just walk away with no harm or no liability that's been triggered. But again, that requires, agreement between or among the parties that are involved in the contract. Discharge when performance becomes either impossible or difficult. We'll talk about some situations that can arise in either of those situations. And then obviously lastly, discharge by other means. So this is kind of like a roadmap that we're going to be looking at as we go through this chapter for different ways in which we can discharge contractual obligations. So fortunately, most contracts, are completed because people do what they say they're going to do. So, the aforementioned, you make the required payments on a vehicle, you make all the payments at the very end, then you get the title to the vehicle, you own it outright, the contract has been completed. If I'm a retailer and I'm ordering inventory and whoever that my supplier is, if they actually deliver, whatever the inventory order was, and then I pay them, that's a completed contract. A lot of times it's, it doesn't get the celebration that it necessarily should, because when contracts go bad, usually they go very bad. But when everyone says and does what they are supposed to do, that's the best of all possible worlds that we can kind of have when it comes to contracts. When we talk about discharge by non-performance, should we have an otherwise valid contract and one party fails to perform, then the non-breaching party, and what that means is the party that has done nothing wrong, their obligation usually is discharged as well. If I hire a company to, let's say, install a pool in my swimming pool in my backyard, and let's say for some reason they just don't even show up, obviously I don't owe anything because they didn't do anything. So that would be, discharge on my end as a non-breaching party. I would not have any obligation to pay on that contract. If we're looking at adequacy of performance, there's a few kind of elements or instances where this can arise. So what happens if you hire someone to do a job and let's say they don't complete it 100%, but they complete it, 60%, 70%, so they're most of the way there. Usually in that situation, what you can do if you're the party, again, that's not breaching, because obviously if you don't complete your end of the agreement as promised, you're the one that's in breach. But let's say, you did perform substantially. Whatever it takes to complete the project or the job or whatever the contract entails, you can reasonably deduct that from what the breaching party, could expect in the contract. So let's say the swimming pool example. Let's say, again, I hire a company to install a swimming pool. Maybe they've dug the hole and they've maybe, done some of the initial work in terms of laying the concrete, but then for whatever reason they cease and they basically say we're done at this point. We can't do any more work for whatever reason. And so maybe they're 60-70% of the way done. What is it going to cost me to have a different company come in and finish the project? Well, assuming everything was provided for and installed correctly up to that point, then that's a fairly easy kind of, kind of like math formula to kind of solve. It's like, well, what do I have to pay this second construction company to finish the swimming pool? And whatever I pay them, I'll just deduct off what I was going to pay the first construction company. The problem that can arise is, well, what if you haven't substantially performed? So maybe they dug a hole, but that's it. The first swimming pool company, and so maybe they're only 30% of the way into the project. Well, it's really difficult to expect much compensation at that point if you are the breaching party. They may get some compensation, they may not. Everything really is going to be contingent upon, well, what is it going to cost a subsequent company to come in and finish what should have been done by the first company. If you're looking at fault of the complaining party, if in a contract, sometimes what you'll have are specifications that have to be followed. And if someone doesn't like, let's say whoever, I'm hiring to do a project, if I'm not happy with their performance, one of the defenses that they can offer is, well, if our contract had specifications like a blueprint or schematics or just whatever specific instructions on how to complete their contractual obligation, if they followed everything correctly, then there really is nothing for me to complain about. One of the best examples, and I've given this, for years now, when I was in law school, my contracts professor, his interesting character, his name was Vern Davidson, and brilliant contracts professor. I mean, he knew contracts, perfectly. And he was a cooking enthusiast. He really loved the kitchen. He loved to prepare meals. He hosted parties in his home frequently. And so, one day he decided that he was going to have his kitchen redesigned. He wasn't happy with how the original construction was, the layout of the kitchen. So he basically wrote down, on a sheet of paper, he kind of sketched out what he thought his kitchen should look like. From the island in the center to the cabinets, the position of the appliances, all the various details. He even went to the extent of picking out like the wood for the cabinets, the color, the type of flooring he wanted to have in the kitchen, the type of appliances. So he was very detail oriented because that's where he, thrived, was in the kitchen. Anyway, so he hired a company. He gave them basically all the instructions. They followed the instructions perfectly. And once it was completed and all the dust settled and everything was cleaned and they walked him through the kitchen to show him, that everything was completed as per the contract, he hated it. He did not like the final product, but he knew as a contracts professor that the company followed their instructions to the T perfectly. And so that's just on him at that point. So he was kind of stuck with the kitchen that he liked even less than the kitchen that he had originally in that particular home. So if someone is going to be complaining about somehow the performance was not satisfactory, if you had specifications to refer to, as long as you follow those specifications, you're going to be insulated from that type of liability. Where it can kind of come into play is if you have what's called a satisfaction contract, and that's where you hire someone to complete some kind of task, and the language basically in the agreement specifies that it has to be completed to the satisfaction of the party hiring the other party. Usually courts, if you end up litigating a case like this, they're going to gauge your dissatisfaction in terms of, was it made in good faith, or are you just an unusually picky person? My advice for clients is that if you're trying to enter into some kind of contract to perform services or provide a product, if there's ever any discussion of to the satisfaction of the other party, I would probably try and encourage you to use different language. Maybe insert specifications. That's probably a good kind of way to transition the discussion. Say that I'm not comfortable with this idea of performing something to your satisfaction, but if you list out the specifications, I'll make sure that I follow them precisely. ABC, whatever is expected. So, but all of these situations here on this slide really kind of get to the heart of, well, what is the adequacy of performance when it comes to, is a contractual obligation, has it been discharged yet or not? When we look at time of performance, normally time is considered whatever is reasonable for what you're contracting over if time is not mentioned. A lot of times time is mentioned, and it's mentioned in a couple of different ways. If time is of the essence, you could actually, input that or insert that into the contract that, performance is expected to be completed as soon as possible. Okay, well, that indicates to everybody in the agreement that time is essential, and we want to get moving on this as quickly as possible. Even then, as soon as possible is kind of vague because, well, what is as soon as possible? I mean, if you're constructing a home, as soon as possible is going to be months. If you're, installing a swimming pool, as soon as possible, maybe a few weeks, so it really is kind of a fluid kind of concept. You can never go wrong. I say that now, but, in theory, you can never go wrong if you list an actual deadline. I want this completed by a specific date. And then at that point, you don't need to say anything else. Everybody that's in agreement with this contract, they know that, performance has to be completed by whatever that date is in the future, 90 days from the signing of this contract. And then we know as we get to day 90, it better be finished or somebody is in breach at that point. So that's what I always recommend for time of performance. Indicate, a specific calendar date you would expect performance to be completed by. You can do it early, but we don't want it performed after a specific date. And then if you do that, then it's clear to everybody when that specific date is. If you're looking at a breach versus anticipatory breach, breach is when the date has come to perform and a party to the contract does not perform when they're supposed to. That is breach. There's no question about that. So if let's say I have a promissory note with a lender, and maybe the payment is due in 1 calendar year from today, and so 1 year fast forward in time, and let's say I don't pay. I'm in breach at that point. Anticipatory repudiation is kind of an anticipatory form of breach. So this is where a party may declare that they're not going to be able to fulfill the contract as agreed. And so you can kind of have repudiation in a couple of different ways. It could be by just express statements by the other party to the contract. They may say, look, I can't have that pool installed in your backyard by 2 weeks from today. It's not going to happen. Or maybe I'm the debtor and I'm alert whoever the lender is that an upcoming payment, I'm not going to be able to make that payment going forward. So maybe I'm giving them kind of like a heads up. I still might have 2 weeks to perform, but I know that when 2 weeks arrives, I'm not going to be able to perform as per the agreement. So that's an example of anticipatory repudiation. What I like to discuss with students this case, and I encourage you to kind of read this slide in more detail, but it involves the sitcom TV show Friends, which I know has been off the air for a while now, almost 2 decades. And one of the issues that arose while that show was being aired a few seasons in was that the cast, the 6 actors, who were, comprised, the main characters on the show Friends, they collectively alerted NBC and the producers of the show that they wanted more money, even though their contract still had, I think, another 1 or 2 seasons left on it before they would enter into renegotiations. But they alerted the show early, saying that they wanted a raise immediately or they weren't going to basically perform their acting services. So I discuss this because it's kind of like a situation that involves anticipatory repudiation or an anticipatory breach. The ultimate kind of conclusion in this case was that the parties agreed to settle, and what happened was, they did get an increase in the rate of pay per actor per episode. They didn't get what they were originally asking for, but they did get a raise. And what I like to always kind of frame the discussion with this particular case is, I usually ask students to take the role of, let's say you're NBC, so you're the show that's paying for everything. And you get a notification that these actors, are basically kind of warning that they're not going to perform, as they have promised through contract, unless you pay them more money. And I usually ask students, well, what is the range of options, at NBC's disposal, and usually students are pretty clear to kind of, identify the extreme positions. On one end, they could just say, please, don't quit on us, or, please show up to work and we'll pay you whatever you want, so they kind of just give in. NBC could have done that. Probably not a good strategy, because if you do it once, then, they may come back a year later and do it again, or other shows might start doing that. So it's probably not a practical option, but it is an option. The other end of the spectrum is you could kind of come down on them very draconian, very heavy, and say, look, show up to work, and if you don't work, you're all fired. And what that means is that for the duration of their contract, they can't do any other acting. So they can't be in TV shows or movies, and in addition, they wouldn't be paid either. So that would be kind of like the other extreme, very heavy-handed in that approach. And obviously, in the center is where we're entering into negotiations for some kind of settlement or compromise, and that's obviously the way NBC went with this. And again, if you're being alerted that the other side isn't going to perform, again, you've got a couple of options. You could just wave it off and say, fine, don't perform. I'll just get somebody else to do this. You could, automatically launch into litigation if you wanted to do that, or you could maybe try and figure out, can we reform the agreement so that it is still possible for the parties to perform. So if you are kind of given a heads up by another party to a contract that performance is not going to occur as promised, you could wait and see, so, that's what NBC could have done. They could have waited to see if the actors were actually going to not show up to work. And then, at that point, if they breach, then sue. You could do that. You could request an adequate assurance of performance. So you could say, look, I know that you've alerted to me that you might not perform. I need some assurances if I'm going to work with you that you're still going to perform as promised. And so that could be something in writing or whatever you would require to demonstrate that you've been assured that performance is going to result. You could just proceed immediately with an action for damages. As soon as the debtor or the other party says, I'm not going to do what I'm supposed to do a week, 2 weeks, a month from now, whenever, you can just say, fine, okay, and then immediately just call your attorney and say, file a complaint, let's sue. Or the last option there, just offer to say, okay, fine, I'm just going to cancel the contract. It's not worth it to sue you. It's too much time. I'm not going to get anything out of this. I'll just never do business with you again. And so just walk away. You have that at your disposal as an option if you're the party that has not breached. So again, when a breach occurs, that's when someone doesn't perform when they're supposed to. Anticipatory breach, or sometimes called anticipatory repudiation, that's where you're giving kind of a heads up, saying, I know I'm supposed to perform in some window in the future, but I'm telling you now I can't do it for whatever reason. If we're looking at discharge as it relates to a series of different conditions, this comes up frequently in different types of contracts. Conditions are events that either have to occur or will occur that will either cause a contract to spring into life, or it could cause a contract to cease to exist anymore. So the three conditions, and these are all like relative to time: condition precedent, condition subsequent, and then concurrent condition. So condition precedent is a situation where something has to occur before we can trigger that a contract has sprung into life. I give the example there of a business lease subject to rezoning. Many of you, I know you have aspirations of starting your own business one day. And let's say whatever the business is, let's say you find a location that you think would be perfect. But if you know anything about land use in the United States, you know that everything is subject to zoning. There's areas, and this is all done by urban planning. And so there are areas in think of like the Orlando area that are designated as residential. So it's only for dwellings like homes, apartments, condos, things like that. There's also commercial zoning. So that's where we have businesses. That's where we want them to be located. We have industrial areas. So if you're kind of like, more not necessarily into manufacturing, but manufacturing-like facilities, where maybe, there's some level of construction that's going on, or fabrication of materials, that would be for that purpose. And then as you get farther away from more urban areas, you get into suburban or rural areas, you might have land that's zoned for agricultural purposes. So let's say you find a parcel of land that you're like, this would be great for my business, but maybe it's not zoned for your type of business use. So what you can do is you can still submit a contract for purchase or to lease, and then you could put as a clause in that agreement that it is subject to getting like zoning, like rezoning, or maybe like a variance request, where you're saying, I would like to have a special use permission that varies from what the zoning is for this parcel of land. So if you never get that zoning, approved, or that variance, then no contract ever springs into life for the sale of that property or for its lease. If we're looking at a condition subsequent, this usually is where you have a contract that currently is in existence, and so it's being performed upon, but some event occurs that causes that contract to cease to exist anymore, so it terminates any further obligation of performance going forward. I give the example there of an employment contract. Again, whether it's verbal or in writing, it doesn't matter, but some businesses, they have, as part of their requirement, is that, besides the initial hire, while you're employed, you may be subject to random drug testing. And so, let's say that, someone is working for a particular business, and, 6 months into their employment, they're picked like a name out of a hat saying, okay, it's time for you to go submit for drug testing. And let's say the person fails. And we're assuming it's not a false positive. They actually did fail. They had drugs in their system. Then at that point, they're fired, if that's the policy for that particular business. So even though they had an employment agreement, written or verbal, doesn't matter, that agreement is terminated with the positive test results if that's what occurred. Concurrent conditions, these are usually situations or conditions that have to happen simultaneously for a contract to spring into life, and then it terminates almost immediately. The example that I give frequently, and I know I've given this before in this class, when you're actually shopping in a grocery store. So everything on the shelf is an offer. You pick it up as an acceptance. You take it to the cash register to be checked out. As they're bagging whatever you're purchasing at the grocery store, payment is expected, and so you pay them. They give you the receipt. They give you your merchandise. Everything is completed in that single moment. So that's considered a concurrent type transaction. But these are situations where, again, they pertain to the performance of an agreement. They either you cause an agreement to spring into life. That would be a condition precedent, if those conditions have been satisfied. They could cause a contract to terminate. That would be condition subsequent. Or in like a retail transaction, it's virtually a simultaneous event or concurrent set of conditions that would then terminate any future performance, because performance that was required was actually given. You can have discharge by agreement of the parties. So whether it's by agreement, mutual rescission, however you want to kind of frame the language for this, you're basically just saying that you want to terminate this agreement, and if the other side agrees, then that's fine. There's a couple of different options at your disposal. You could actually substitute a new contract for the original contract. So maybe you don't like how things are unfolding under the existing agreement, but you still want to maybe do business with this other party. So you can if you both agree, you can say, look, let's set aside this original agreement and let's craft a new one. You can do that. You could also have a novation. That's a new contract with maybe a new party, for whatever you're trying to contract for, goods or services. You could also do what's called an accord and satisfaction. That's where if you have a dispute about the original contract, a new agreement can be formed as to the performance or accord, and then as soon as it's executed, then that's considered the satisfied part of it. So, again, I've tried to emphasize, as we've discussed contracts in its many facets over the past few chapters, that they're very adaptable. As long as the parties can maintain communication, and as long as each party is willing to kind of work with each other, you don't have to launch into litigation mode. You can avoid a lot of problems by just kind of keeping that communication flowing. There are going to be times when you will have to go into litigation mode. I think that that's why we have the court system, and it's a necessary function at times. But I think that more often than not, you probably can figure out a way to avoid litigation, because litigation doesn't serve anybody. In most cases, it just ends up being very costly, very time consuming, and it's a distraction from what you're trying to do, which is be a business person. Mutual rescission, again, this is another facet of, discharge by agreement of the parties. And so, whether it's a waiver, substitute agreement, accord and satisfaction, I've already kind of went through those details, but this just gives you a little bit more, of a glimpse into some of the nuanced facets when parties, basically are agreeing to kind of walk away from an existing agreement. If we're looking at issues pertaining to the impossibility of performance being executed, then that would be a way of being excused from performance. So I give some examples there. Maybe what you're contracting over is scarce, like a rare painting I give as an example, or one of a kind, whatever it is you're trying to contract over. If for some reason, even though the contract has already been executed, like drafted and signed, if it is destroyed in transit, obviously there's nothing that you can really do at that point. If there's an adoption of maybe a new law that prohibits performance, so no contract, as we know, is going to permit the violation of the law and be enforced in the court of law. So if there is a change in the legal structure, that could cause a contract to cease to exist. If your business model in terms of an organization is, let's say, sole proprietorship or partnership, then the death or disability of someone that's instrumental in the performance of that contract, that would cause the contract to cease to exist. This doesn't necessarily apply for corporations, because corporations obviously they have a longevity that spans beyond the lifespan of who originally created it. Or if you can demonstrate just in general that there's a lack of good faith and fair dealing. So for all of these situations, if it's deemed to truly be impossible, then that would excuse performance then by the parties. Another aspect that comes up is, well, is it impractical? So we're not saying that it's necessarily impossible, but it is impractical. And so here contracts may be discharged. It's very factual, specific. Maybe there's a natural catastrophe or war, things that are outside the scope of predictability by the parties. Normally, if you're trying to argue that you have a change in your cost structure so that this deal is no longer profitable, that normally is not an excuse to say that performance is impossible. The only way that maybe a court might consider it is if it has become so disproportionately cost prohibitive that if you were to be forced to perform, you may go into bankruptcy. Courts then might entertain this idea that maybe performance is kind of de facto, impossible at that point. If it's a temporary impossibility, then that normally has no effect other than maybe granting an extension of time on performance. We certainly here in Central Florida, we know the ravages of hurricanes. And sometimes hurricanes, they'll blow through and they'll cause damage. And as long as it's not, where if the actual subject matter has been destroyed, but let's say that for whatever reason, for a few days, roads are closed, or maybe the electrical system is down. So these are things that will get back up and running within a few days, a week, or two tops. You can still be expected that you're going to perform on the agreement, but you're going to be given an extension of time because obviously whatever it is that happened, so bad weather, minor events, from Mother Nature, labor strikes, these things usually will get resolved in the short term, not the long term. The last slide that I have for this chapter is discharge by other means, and this is labeled under this idea of operation of law. So bankruptcy is a great example. If any of you have ever known anyone that's gone through bankruptcy proceedings, the theory of bankruptcy, and we get into this in a lot more detail in business law too, is that you're going to federal court and you're asking to have either some, most, or in some cases all of your debt wiped clean as an obligation. So just you want it to be discharged. And there's a lot of details when you can and cannot discharge certain types of debt. But the idea of going into bankruptcy is that every contract that you have is basically open to be renegotiated. It could be just discharged, or at a minimum, it could be renegotiated so that maybe your principal has been reduced, your interest rate has been reduced, your monthly payment has been reduced, whatever the federal bankruptcy judge deems appropriate. But that has the effect of discharging the original contract, and a new agreement may kind of emerge in its ashes. That is something that, again, the bankruptcy court will have to determine. If we're talking about a statute of limitations, so this usually pertains to the right to kind of bring a cause of action. In most states, if we're looking at a contract dispute, it could be anywhere from 2 to 4 years, depending on the nature of the contract. Then if you wait beyond that time window, if you wait too long, that acts as an expiration. And so at that point, it's discharged. Even though you may have had a great case, you waited too long in order to bring your cause of action. So if you're going to sue at that point, you need to just kind of make that decision and then follow up on it. Don't just set it aside, because time has a way of escaping us very quickly. So always be cautious about that. And the last thing is if there is an actual time limitation that's stated in the contract, because in many cases you can actually do that as well. In addition to the statute of limitations, put some kind of time window for, if you're going to seek recovery for some kind of breach or alleged breach, that you put this kind of like window in of time, whatever the time period is, 6 months, year, 2 years, whatever. And again, if you wait beyond that, then again that acts as an expiration. So I hope this helps, kind of clarify your reading on this chapter involving discharge of contractual obligations. Like normal, if you have questions, please feel free to reach out to me anytime. But I thank you all for taking the time to watch this video. Have a wonderful day.